to Making It Last, where we share ideas to help families tackle major issues. I'm your host, Regina DeMeo, and with me today is Clark Fleckinger, who's been helping families for over 30 years with criminal cases. Thanks so much for being here.
It's my pleasure.
So let me ask you, what's the most common type of criminal case that you handle in Montgomery County?
Well, the most common type are misdemeanor type of offenses, driving under the influence, drug cases, theft cases, those kinds of cases. But in other jurisdictions, I also deal with a lot of drug conspiracies and things of that nature.
Wow. So what's the difference between a misdemeanor or a felony?
The severity of the penalty, the egregiousness of the offense. Misdemeanors are typically your less serious criminal offenses. Those things like low-level larcenies and thefts under $500, driving under the influence, simple possession of controlled substances, those kinds of things. Felonies are typically things which are possession with the intent to distribute or distribution of controlled substances, the various forms of homicide, robberies, rapes, and other sex offenses, burglaries, which is the breaking into dwellings and or businesses. So those are typically felonies, and they're typically stated as either felonies or misdemeanors by statute. And typically the kind of punishment that one gets in a misdemeanor is going to be maxed out at roughly a year in most instances. And in felonies, you're looking at, in terms of a statutory maximum sentence, you're looking at greater sentencing discretion, or I shouldn't say discretion, but the ability for a judge to be able to go impose a sentence of incarceration which is substantially higher than what would be the case in a misdemeanor.
Got it. So, I mean, one of the things I found fascinating about criminal law, especially now, is it's constantly changing. Like, they have to go back and revise some of their definitions. For example, with the information age,
Sure.
You can harass somebody through Facebook, Twitter. There's now cyber stalking.
Sure.
So, do you see more of those kinds of cases coming up now?
All the time.
Really?
All the time. And what happens is that threats are frequently, more often than not, being communicated by electronic means, i.e. text messaging, emails, those kinds of things, rather than on a face-to-face basis. It still happens on a face-to-face basis, but frequently the threats and the stalking are communicated by way of text messages, which can be many, they can be threatening. So yes, you're right. That's exactly what's going on now.
It just seems so stupid to me because it's so easy to trace, right? I mean, if I threaten you verbally, it's going to be your word against mine. I'm not going to do that. But,
I understand.
But meanwhile, if I'm emailing you every day, if I'm calling you 10 times a day, if I'm putting stuff on Facebook, Twitter, that's just out there, and that's evidence that you could then use against me.
The people who are doing that, who become defendants, are doing that and memorializing their threats all the time. And it's not only happening in the context of criminal cases, it's happening in the context of other matters as well. So people are writing things down, and it lives forever, and everybody is a witness to that at the point that somebody writes it down and it becomes apparent as a threat when it shows up in email. It's very easy to put that into evidence, and there's really no question as to whether or not the threat was communicated, whereas in the event of a face-to-face confrontation where there's no type of recording, whether it's an audio recording or a visual recording or a digital recording, the evidence is there, and it makes it very difficult to defend.
I was going to say, yeah, your job's gotten a lot harder now.
But by the way, the same thing is true with regard to complainants. Complainants in the criminal justice system are also doing the same sorts of things. So as much as defendants who are becoming involved in that kind of threatening type of behavior, it then becomes apparent that complainants are frequently involved in that whole process to a far greater extent than they ever would have admitted at some time previous, and the memorialization of that
like when I'm egging you on.
Yes, that's exactly right. Provoking the
right.
Provoking the conduct.
Mm-hmm. Interesting. So, I mean, I think we all know what Miranda rights are, right? But so when someone gets arrested, and I've never been through the process, hope never to have to go through it. But who should that first phone call be to?
Well, if you've got a lawyer and you've got that lawyer's, typically arrests are made at times which are inconvenient for the lawyer. The lawyer isn't necessarily sitting by the phone. But if you've got, if you're arrested and you have a lawyer and you know that lawyer's cell phone, you probably ought to give that lawyer a call. On the other hand, if you don't have a lawyer and you don't have easy access to that lawyer, you know, your best bet is probably to give a call to a spouse, a boyfriend or a girlfriend, an adult who is able to, you know, contact a lawyer, contact a bondsman, understand what the situation is, and know that the person is being detained and is not going to be where they are expected, and to take steps which can assist the defendant who's just been locked up or just been arrested.
So why do some people start talking to the police instead of just waiting for the attorney to show up? I don't understand that. Like, by now we should know, keep your mouth shut.
Well, because they think they're smarter than the police.
I see.
And they think that they can talk their way out of whatever problem that they've gotten themselves into. They think that they're going to be able to tell the police what took place and that the police are going to believe them, and that the police have an understanding of facts that really only they have an understanding of. And nobody perceives that, well, very few people perceive of themselves as a criminal and being involved in criminal behavior, and most people have the perception that everybody around them thinks the same. That, you know, nobody perceives me to be a criminal. I'll just explain what happened. The police officer will understand what I'm saying and then take steps to let me go and to do whatever it is that's necessary in order to further the investigation. But they don't think that they're going to incriminate themselves, and frequently, most of the time, they're incriminating themselves. Right. And they don't understand what an incriminating type of statement is. Simply indicating that you are present may be an incriminating comment.
I see what you're saying. Yeah, so when you go in, sometimes do you find that like way too much damage has been done because they've been talking too freely?
Sometimes, but that doesn't always happen. Most of the time it doesn't happen. First of all, they don't give the kinds of statements all the time which are truly inculpatory. Okay. You know, they try to explain around the situation, and frequently, even if they do make a statement, they haven't been properly warned, and so there are safeguards which are set up in the system. You brought up the Miranda issue previously, and when police encounter people that they are investigating or encounter people pursuant to their investigation, and the person becomes the subject of a custodial arrest type of situation, the police are supposed to advise them at that point in time that any statements that they make in response to any sort of questioning or interrogation could be used against them. And so if the police don't do that, if they step over the line in that regard, that can be made the subject of a motion to suppress the statement. And it can be made the motion to suppress any of the fruits of that statement as well.
Right. So do you find yourself mostly doing plea deals, or do you actually take most cases to trial?
Well, I think that most lawyers probably have most of their cases end up in some sort of a plea bargain. But it depends on the jurisdiction. For example, in the federal system, I think my statistics are correct, about 95% of the cases, criminal cases that are indicted and charged, end up in a plea bargain type of situation. And the reason for that is that the federal law enforcement agencies are typically doing their investigations long before, and are doing them in a much more significantly. The investigation of crime by federal law enforcement agencies is very different and much more professional than it is in state and local law enforcement agencies. And so by the time they have indicted somebody for a criminal offense, they usually have a substantial amount of evidence. And as a result, plea bargains typically take place. Whereas in more local type of offenses, the thefts, the driving under the influence, the assault, those kinds of cases result in quick investigation, an arrest, and therefore the facts for the prosecution are probably not as well developed as in the federal system, and therefore the defense attorney has a little bit more to work with, the prosecution has a little bit less to work with, and there are far greater ambiguities in the state of the evidence than what would exist in the federal situation. So in answer to your question, which is a long way to get to an answer, there are probably less plea bargains in the state and local system than there are in the federal system, and far more cases go to trial in the state and local system than do in the federal system.
So do you see this as a game? Because I see it as a game. I see it as like, the courtroom is an arena, basically, and then we're both gladiators. If I'm the prosecutor, I have to meet my burden of proof, and if you're the criminal attorney, then you're trying to push me to make sure that I am meeting that burden of proof. But it's a game, and it's like, hey, may the best man or woman win. It's a battle of wits. Like, that's kind of how I see it. Do you see it that way?
Well, I understand what you're saying, but I don't necessarily agree with that. It's a game. It's a game in the sense that we are all trying to advocate our position. Right. We're all trying to put a spin on the facts that advances the position that we are taking. So in that sense, it may be a game, but it's a game that has substantial consequences. And in the context of criminal prosecutions, a criminal prosecutor, whether working for the state's attorney's office or the U.S. attorney's office, has a different role than any other attorney. And the role that a prosecutor has is not like any other advocate, but rather to do justice in the case. And so in the event that a prosecutor becomes aware that the facts as they understand it don't justify a prosecution, I think the prosecutor is obligated to take steps which will terminate that prosecution, or to ratchet that prosecution down at some level. And that's a little bit different than what any other lawyer has to deal with. The prosecutors have a different obligation.
No, that's a great point. Yeah, I mean, if somebody is being prosecuted for murder, and meanwhile somebody else gets arrested and they claim that they're responsible for that murder, they need to go investigate.
Sure.
That. Yeah. Well, we're going to take a short break,
okay,
and then we will be right back.
2 outs with a runner on first base. Now the big guy comes up to bat, hitting .342 with 92 RBIs and 36 home runs. First pitch, back.
Chill raw and prepared foods promptly. 1 in 6 Americans will get sick from food poisoning this year. Keep your family safer. Check your steps at foodsafety.gov.
Welcome back to Making It Last, where we share ideas to help families tackle major issues. I'm your host, Regina DeMeo, and with me today is Clark Fleckinger, and we've been talking about criminal cases. Thanks so much for being here.
Again, it's my pleasure.
So we were talking about the ethical standards for prosecutors. What are the ethical standards for criminal defense attorneys?
Well, there are quite a few, but basically, one of the things that well, there are many things. Let me start off with a few of them, but there are more. First of all, you can't lie to the court. You can't mislead the court. And you can't have your client, the defendant in a criminal case, or a witness for the defense lie to the court and provide perjured type of testimony. For a criminal defense lawyer to do that would be called subornation of perjury. It's unethical, it's illegal, it's a crime. You can't do that. So you have those kinds of obligations that you have to the court system and to the basically the system. You also have obligations, ethical obligations to your own client. You've got an obligation of confidentiality. You can't divulge things that your client tells you in the context of the attorney-client relationship and in relation to the case, which at all without your client's permission to do that. Now, as a practical matter, a lawyer has to make judgment calls all the time, but a criminal defense lawyer is never going to reveal, as a general proposition, some sort of confidence that a client has revealed. You can't tell, for example, anybody if your client has admitted to having committed the crime that they are being charged with, even though it's still my obligation to defend that person, and my obligation in that context, even though my client may have admitted that he or she committed the crime, is to make certain that if the client decides to reject any sort of a plea bargain that may or may not be available in the case and pursues the matter to trial, is to make the state or the federal government sustain their burden of proof of proving my client guilty beyond a reasonable doubt under circumstances where my client has no obligation to testify, my client has no obligation to put on any sort of a defense, my client is presumed to be innocent of whatever he or she has been charged with, and so it's the prosecution's obligation to overcome that burden, and we don't have to put on any evidence at all, and I can cross-examine witnesses under circumstances trying to undercut the credibility of the testimony, even though my client may have indicated at one level or another that he or she committed the crime that they've been charged with.
So let's talk about Zimmerman for a second, because there's so many amazing things to glean from that case. But
Sure.
There was no question that this person was the person that had pulled the trigger.
That's true.
Right. And yet we went forward with a jury trial, and he was ultimately acquitted.
Because it's not necessarily illegal to kill another person. It's illegal to kill another person when you don't have some sort of a defense to doing that. The state kills people. The state executes people all the time. That's not a crime. And although it's still a homicide. All a homicide is the killing of a human being. And so if a person is acting in self-defense, for example, or in defense of another person, then under appropriate circumstances, that is a defense to the a charge of murder in the first degree or murder in the second degree or some sort of level of manslaughter, whether it's voluntary manslaughter or involuntary manslaughter.
So why is it, I don't think everybody understands, that somebody could be tried criminally, like, for example, OJ, and then be tried civilly? So why is it that, we all think that you only get one bite at the apple, but actually people can get two bites at the apple?
Well, I don't think it's really getting two bites at the apple. When a person is being criminally prosecuted, their liberty is at stake. If they are convicted of a crime for which a sentence of incarceration is provided for by statute or by common law, then that person can go to jail, and that person cannot be tried for that same crime a second time, even though there's been a favorable result for that person during the course of the first trial. It would be a violation of the Double Jeopardy Clause of the U.S. Constitution to try that person a second time. But the issues in a civil case are completely different. In a criminal case, a crime has been committed not only against the victim of that crime, but also against society. And so the state or the federal government has an obligation to prosecute that crime on behalf of the society as well as on behalf of the victim themselves. On the other hand, in a private cause of action where somebody is looking for to be compensated for the damages that they've incurred as the result of a criminal act by somebody, the private party can file a lawsuit, a civil lawsuit against the criminal defendant and try to obtain compensation for the damages that they sustained. For example, as you're aware, in the O.J. Simpson case, the O.J. Simpson was prosecuted by the state of California for the crime of murder in the first degree. He was found not guilty of that, but the parents of Nicole Brown and Ron Goldman were still able to bring a civil lawsuit against O.J. Simpson as a result of the loss that they had sustained as a result of the criminal conduct of O.J. Simpson. The loss that they had sustained was the love and affection of their daughter, of their son. The children had sustained a loss with regard to the potential income of that mother or father, and so they have a right to bring a lawsuit against the person who perpetrated the act that caused them that lawsuit. And the standard for finding a person civilly liable for the damages that they have caused is substantially different than the standard for finding a person guilty of the crime which they are accused of, even though the crime that they are accused of is the same act as the conduct which caused the damages in the civil case. In the context of a criminal prosecution, the standard for finding a person criminally liable for their alleged criminal conduct is guilt beyond a reasonable doubt that the state or the federal government has the burden of proving, whereas in the context of a civil case, the private party, the plaintiff, has the burden of proving beyond, by preponderance of the evidence, as a general proposition, that the person that they are accusing of having committed some sort of civil wrong against them should be civilly liable and should have to pay some sort of damages to them. And so the standards of proof are substantially different.
Yeah. So do you think that our jury system is flawed? Because obviously that's a major question that is now being raised as a result of Zimmerman, and I guess you could say, dating back to O.J. I mean, O.J. was actually going on when I was in law school, and I remember thinking, wow, that was a brilliant way to manipulate the jury, right? I mean, that's how I saw it. And now we have the opposite outcome, which is apparently everybody's up in arms because the jury system seems to have failed in the Zimmerman case. How do you feel about the whole thing?
I think the Zimmerman jury, and I think the O.J. jury in both criminal cases did the right thing. They applied the appropriate standard of proof, which is guilt beyond a reasonable doubt, applying also the presumption of innocence to the person accused in the case. And, in both of those cases, the defense was able to mount a credible defense, at least to the jurors that were listening to the evidence on a daily basis, unlike us, who saw these little snippets every now and then,
right,
weren't present at the time of various court rulings with regard to whether or not certain kinds of evidence was going to come in or was not going to come in. So when the jury was instructed that they were to consider evidence in a particular way, and they were to apply the evidence in a particular way and apply various presumptions in a particular way, I think they did the right thing. I think they did the conscientious thing. And while it is true that most people thought that O.J. Simpson was guilty of having committed those homicides, and I think that he was guilty of having committed those homicides, I think that the criminal jury applied the appropriate standards and simply determined that the state had not proven beyond a reasonable doubt that O.J. Simpson had committed those offenses. I think the same thing is true with regard to the Zimmerman case. I think that the jurors are getting an unfair knock. They were the ones that swore to uphold the law, and they were the ones that were sworn to uphold and to apply the instructions that they were given. This is not about some politically correct social agenda. It may be that we want to change the law, or that Floridians might want to change the law with regard to stand your ground.
Right.
But the law, and by the way, the stand your ground law wasn't even in play during the course of the George Zimmerman trial. Everybody thought it was. It was simply a straight up self-defense. It wasn't the stand your ground law was not in play. But even if you think that stand your ground or self-defense was inappropriate under these circumstances, or even if you think that the commission of the crime was racially motivated, the fact of the matter is that that is not a criminal jury trial of a particular defendant is not the place to be making political statements or to be making sociological changes. You've got a person's life on the line, and you have to apply the law as it will be applied for everybody who comes into the criminal justice system.
Yeah, but it seems like a lot swings on the actual jurors, right? You're supposed to be tried by a jury of your peers, and clearly Zimmerman was not being tried by a jury of his peers. That's part of, I guess, the issue.
Well, I don't know. I'm not certain why you're saying he was not tried by a jury of his peers. Are you saying because there were no men on the jury?
Right.
So? I don't think, they were his peers in the sense that they were citizens just like him. Are you saying that you have to have only a jury of men when a man is being tried, that only a jury of African Americans when an African American is being tried, that only a jury of Latinos when a Latino is being tried? I don't think you can do that, and that's not the way the jury system is set up.
So there is no, I've never had to create a jury trial, so I never want to deal with a jury trial, but so there is no requirement to have balance within the jurors of social or economic backgrounds or ethnicity, nothing. No, there's no requirement, but by the same token, the Supreme Court has indicated that you can't discriminate against prospective jurors. You can't strike a prospective juror from the panel that's going to ultimately consider the case simply because that person is of a particular racial demographic or of a particular gender demographic. So you can't discriminate on that basis, but you can discriminate against prospective jurors on the basis of the fact that that they've been previously arrested or because of their profession. Or, nobody wants us on a jury.
Criminal defendants, as a general proposition, don't want police officers on the jury. They don't want the families of police officers on the jury, and so it's fair for a defendant to strike as a prospective juror if that jury has significant connections with the police.
Makes sense. This has been great. If somebody wanted to contact you for further information, how would they do that?
Well, my name is Clark Fleckinger. I'm in Rockville. My address is 111 Rockville Pike, Suite 980. My telephone number is 301-294-7301. Feel free to give me a call.
Awesome. Thank you so much.
Thank you.
Thank you for tuning in, and we'll see you next week on Making It Last.